All right, good morning, everybody. Welcome to our webinar this Thursday morning on managing absenteeism right before the long weekend. I hope that you are all hanging in there and have got some exciting plans coming up. We are in our webinar today going to be covering managing absenteeism, and in particular we'll be talking about what are people's leave entitlements, managing authorised leave, addressing absenteeism, long-term absenteeism and medical incapacity, discrimination in culture, religion and disability, and then some considerations around long-term ACC cover. We are recording today's webinar, and I understand a copy can be made available afterwards. And as we go, if you use the Q&A function with respect to any questions, and I can address questions at the end, and we've definitely left some time today to address any questions, so feel free to pop those up, and then Alice, who's online with me today, will read those out and we'll deal with them at the end. So without further ado, let's jump in. So first topic is leave entitlements. You'll probably all, of course, be aware that in New Zealand, it's the Holidays Act 2023 that sets out holidays entitlements in New Zealand. This is a really fundamental piece of legislation that sets out and governs leave entitlements for all employees working within New Zealand. It's a piece of legislation that can't be contracted out of, and it contains minimum entitlements that every employee is entitled to. The main types of leave this piece of legislation deals with are sick leave, bereavement leave, family violence leave, public holidays, annual holidays, and how and when you can have closed down periods within an organisation. There's been several changes to entitlements in this area in recent years, which we'll delve into as we go. And in addition to those changes, it's also worth knowing that in 2018, the government established a task force to suggest improvements to the Holidays Act, look at what reforms might be needed following a joint request from unions and employers. The task force has made 72 recommendations, which were jointly agreed by union and business representatives, and the government is looking into accepting those recommendations to be implemented in the near future. Just how and when remains to be seen, and of course it's not surprising that there's a bunch of 72 recommendations. It is quite a complicated act with the way that it is read at the moment, and I'm sure we're all looking forward to having some clarity or a layer of simplicity added, or a little bit more flexibility in terms of the different ways that we do work these days, right? So in terms of the Act and how it stands at the moment, what are employees entitled to? They can have 10 sick days per year, accrued to a maximum of 20. They are to be taken where an employee is sick or injured, or the employee's spouse or partner is sick or injured, or a person who depends on the employee is sick or injured. And I guess that's one of those areas where sometimes a little bit of discussion needs to be had with an employee as to whether the person that they're looking to seek sick leave cover for is a person who is dependent on the employee. There are some definites, for example, children and partners, and sometimes parents or other family members come within this realm as well. The changes, previously, as you all know, we had 5 days sick leave, and it was post-COVID really that the 10 days per year came into being. An employee becomes entitled to these days upon 6 months continuous work with the employer. If an employer requires sick leave prior to, if an employee requires sick leave prior to reaching this threshold, it can be granted in advance, but the employer doesn't have to agree to this. So that is a discretion that employers have. If an employee is not entitled to sick leave and the employer doesn't agree to grant sick leave in advance, then the employee can take unpaid sick leave. Sick leave or any unused sick leave can be carried over from 1 year to the next. And as I've said, that only accrues to a maximum of 20 in any given year. So anything above that would be wiped unless the employer were to, out of its own discretion, allow a maximum of a greater number of days, but there is no obligation to do that. That is sick leave in a nutshell, and we're moving on to bereavement leave. Since March 2021, bereavement leave's entitlements have been extended, and this is by changing the definition of bereavement leave to include situations where an employee or their partner has had a stillbirth or a miscarriage. Otherwise, it is 3 days in respect of bereavement leave, and the entitlements also extend to employees planning to have a baby through surrogacy, adoption, or a fungi arrangement, and to previous partner miscarriages. Otherwise, in respect of bereavement leave, the rules are after 6 months continuous service with the employer, employees are entitled to bereavement leave of 3 days. On the death of their spouse or partner, child, parent, brother or sister or mother-in-law, father-in-law, grandparent or grandchild, or on the end of their pregnancy, as I've mentioned, by way of miscarriage or stillbirth, or on the end of another person's pregnancy by way of miscarriage or stillbirth, if the employee is the person's spouse or partner, the person's former spouse or partner, and would have been the biological parent of a child born as a result of the pregnancy, or had undertaken to be the primary carer of a child born as a result of the pregnancy, or where the spouse or partner of a person who had undertaken to be the primary carer of a child born as a result of the pregnancy. And if it falls outside of any of these categories, then the employee would be entitled to 1 day bereavement leave where the employer accepts that the employee has suffered a bereavement. With respect to bereavement leave, the Holidays Act Task Force has proposed bereavement leave be available from the first day of an employee's employment, so they don't need to wait for that 6-month period, and that 3 days bereavement leave be available to cover a wider sort of net of family members. But again, those changes haven't yet come into play. Then we have annual leave. Annual leave is also known as holiday leave, and basically the provisions within the Holidays Act state that on completion of 12 months continuous service to their own employer, an employee becomes entitled to a minimum of 4 weeks annual leave. 4 weeks is the minimum entitlement, but some employers, as a recruitment incentive, are starting to offer an additional period of leave. That might be birthday leave, it might be a day between Christmas and New Year's, or it could just be an additional week or more of leave. And really, obviously, the ability to be able to provide that often depends on the size of the employer. Some rules to be aware of in respect of annual leave. The first is that annual leave must be taken by agreement between the employee and the employer. If a period required by an employee is not practical for the business, then the employer can decline this request, but in declining that request, an employer must not be unreasonable, or it must be a reasonable reason to decline that request. So, for example, if your workforce of 10 people already had 4 people on leave that week, it would be considered reasonable to decline another person's absence for that same period if it would lead your workforce too light. If the workforce nevertheless could easily carry that, then just the fact that other people are already on leave would likely not be seen to be reasonable. But if it really impacts on workflow, then absolutely yes. Where an employee is not entitled to annual leave, an employer can agree for any annual leave holidays to be taken in advance. So this can create a liability for the employer should an employee wish to depart from the company. So something that should be considered on a case-by-case basis and looked at carefully. But employers do have that discretion there to allow annual leave to be given in advance. If an employer can require its employee, an employer can require employees to take their annual holidays at a particular time, and this can be useful, particularly where the parties are unable to reach agreement about the timing of when to take annual leave, or the workplace has an annual close down period. Quick note about that though, if you're going to require employees to take their leave during an annual close down period, it is prudent to have a close down clause within the employment agreement that very clearly states that for employers are able to be able to do that. Last thing to note about annual leave is in instances where an employee has accumulated a substantial number of annual holidays, an employer can require the employee to take their holidays within 14 days written notice. In our experience, substantial annual leave balances can create a significant liability for a business, as if the employee were to resign, then of course you're obligated to pay that time out, and that can add up very quickly. By requiring employees to take their annual holidays, it not only promotes mental well-being within the workplace to ensure that people are having regular breaks and time down, but it also minimises the liabilities that you are carrying. So just as a practical tip, we do urge employers to keep an eye on what annual leave balances employees have regularly, and then if that is getting up there too high, just a gentle conversation in the first instance with an employee and a suggestion that they take some leave and maybe have a break. And if that doesn't lead anywhere, you can give written notice, provided that's given 14 days out, to an employee requiring them to use up some of their leave. And just a reminder that as we go through all of this, if there's anything else that you need me to cover or questions that arise as we go, pop those up into our Q&A. So we'll move on now to managing authorised leave. As a starting point, always have a look at what the employee's employment agreement or collective agreement and the employer's policies and procedures say. These should include detail regarding expectations of how leave should be treated, and it's important that employers have clear expectations for staff and ensure that they follow these. It's harder to rely on what is in the IEAs or policies if you've been allowing your staff to not follow these in the past. So for example, the types of things that you might want to cover off in your employment agreements or policies is clear guidelines on how annual leave is applied for, whether that is through a portal, through an app, done verbally to a manager or in writing by email, whatever process that you choose as being the best fit for your business, ensure that is clearly set out, and then ensure that people comply with that. So it's best practice, rather than allowing one employee just to come up to their manager and say, I'm going to be off in November this year, and then you're requiring another employee to put that in writing. It's obviously better to have it in writing versus verbally, and it's better to have a consistent approach across all employees. Guidelines should also include how much notice should be provided for requesting leave, for example. 2 weeks, 3 weeks, etc. There's no hard and fast rules on how much notice employees should give. That is just a matter of what works practically in the business and the type of business that you're operating. It's understandable, of course, though, having said that, that employees may need to take annual leave on short notice. So give clear guidance as to what guidelines apply in those situations. For example, an employee might be needing to speak directly with their reporting manager to discuss whether that can be accommodated or not before they then put in their formal request. Then with regard to sick leave, again, policies should have clear guidelines that say how much notice is required if an employee might not be able to make it to work. I mean, you know, quite often we can't give a lot of notice with respect to that. It's the morning that we wake up and feel sick, but you can for example, require employees to report at least 1 hour before their expected work time. And with respect to planned sick leave, if that's with respect to operations or other procedures or appointments that an employee needs to attend, you can include some guidelines around how far in advance, if practical, they can be applied for. The guidelines should also address how notice is to be given. Our advice is that employees should be required to call if they're going to be in at work. If their manager does not pick up, then leave a voicemail or attempt to call back again. We don't recommend allowing employees to text if they are sick, as employees are less likely to make non-genuine sick leave if they need to call into their manager and actually need to speak to somebody. But again, no hard and fast rules. It's around what works well for the business, and tempered with how do you manage or mitigate the risk of non-genuine sick leave within the organisation. We recommend that employees are required to call in every day that they are sick, unless of course they've got a medical certificate in advance clearing them unfit to work for a specific period of time. So an employee might call in one morning to say that they're unwell, genuinely not know how they're going to be the next morning, but rather than allowing them 2 or 3 days off, get them to call in the next morning and check in as to how things are going. If the employee is sick for 3 or more consecutive days, they can be required to provide a medical certificate, and that is at the employee's own cost. If you would like an employee to provide a medical certificate where they have not yet been absent for 3 days, you can ask for a medical certificate, but then that must be at the employer's cost. As you know, employees are entitled to sick leave, family violence leave and bereavement leave after 6 months of continuous employment. But again, an employer can allow an employee to take their sick leave in advance, but we do suggest you be careful around doing this. With respect to bereavement and family violence leave, again, we recommend clear guidelines be provided with bereavement leave and family violence leave. Employees should also provide notice of the requirement to take leave prior to commencing work where possible, and employers are entitled to receive proof of the need to have bereavement leave or family violence leave where that might be an issue. And normally that only arises where there are maybe new employees and you haven't built up that rapport of trust yet, or in certain situations. So that is where I'm up to. Managing authorised leave. I'm sorry, I hadn't flicked through the slide for that, but here are the materials, and in a nutshell we were saying look at the individual employment agreement, set out clear expectations from the start with respect to annual leave, how is it going to be applied for, how much notice. With respect to sick leave and bereavement and family violence, again, how much notice is required, how the employee reports their absence from work. Are you going to let them text, email, or are you going to require a phone call? And you can have proof of sickness for 3 consecutive days. And if you need it earlier than that, that is at the employer's cost. So a few words then about absenteeism. This is one of the tricky issues that we often get inquiries on. It can be difficult to navigate, especially where you've got employees who are taking excessive amounts of time off. They're the recidivists who have got every Monday off or so on. What are some considerations about how you might deal with that in the workplace? So absenteeism, as I've said, is a common issue that many employers are likely to face at some point in their workplaces. It's a difficult area to manage as the law acknowledges that employees can take time for genuine illnesses, and as you will see later on, there are also some rules around accommodating disabilities where we reasonably can. So it is a juggling and a balancing act. Can require employers to strike the balance between ensuring that employees take sick leave when they are sick, but then of course not misusing leave for other reasons. Absenteeism can broadly be defined as a habitual pattern of absence. It doesn't just occur where an employee takes leave without authorization, but it can also occur where an employee requires and or takes significant periods of leave which is known to the employer. This usually occurs in situations of sick leave. Monitoring attendance and making sure someone is actively managing staff is important. This will hold the employee accountable and mean an abuse of sick leave will be less likely, as employees will have to provide an explanation for each of their absences. And if employees are required to check in, do those phone calls, give a reason for their absences, that is a great starting point in mitigating the risk of employees misusing sick leave. As I've already covered, ensuring that the workplace has clear policies that set out those expectations of how and when an employee takes work and when they take leave and when they return to work is also a great tool. That might sometimes also involve calling the employee to seek a specific it might involve the employee calling a specific person each day that they're absent and then meeting with their manager upon their return. Helpful for an employee to be touching base with the same person throughout that process, and so you've got visibility as to how often an employee takes leave, rather than one manager receiving a call, another manager receiving the call, and if there's no communication there, you might miss a pattern of absences. You might also need to speak with the employee about what is needed from them before they're able to come back to work, whether medical clearance is needed, whether any accommodations need to be made within the workplace, so on. So for example, many restaurants and cafes will have a policy where an employee has got a stomach bug, for example, that they'll need clearance from their GP before they're able to return to work. An employer does need to establish in the initial stages whether there is a medical condition which is the cause of the absence. If there is, then employers will need to treat that as a medical incapacity issue. For example, someone with diabetes is likely to have a higher than normal absence rate as their illness causes them to weaken an immune system. Employers should be reminded to be reasonable in the circumstances. So if the employee has only taken a few days over the contractual or statutory minimum, then that doesn't necessarily mean that there is a problem. It could just mean that they've been unlucky, they've caught a few more illnesses than normal that year. But really, if there's a chronic pattern of absenteeism and or people are taking excessive amounts over and above what is in their entitlements, then that's another issue entirely and a problem that we recommend be addressed head on and dealt with. The only way that you'll know that really is through actively monitoring their absences. There's no set standard as to what is a pattern of habitual absences and whether you've got an absenteeism problem or not. Everything needs to be looked at and it must be reasonable depending on the employee's position, taking into account circumstances, the reasons that they have been giving you for their absences, and of course measuring that against the impact on the business or the team, how you cover their absences, the length of the service, the nature of the illness or injury, or the condition that's impacting on the absence. So employee absenteeism does impact the workplace, of course. This is common knowledge. It creates situations of people being short-staffed. It can decrease staff morale, and then present staff have higher workloads and a higher level of stress. So really, it is important to keep track of and not just to manage workloads and manage the stress of people within the organisation that are having to carry that workload, but sometimes absenteeism and serious lengths of absenteeism or high levels of it could be an indicator that something else is going on within the workplace. Are they not enjoying their role? Are they not engaging with their role properly? Or are there wider issues with respect to bullying or harassment that need to be addressed? So really keeping that pattern of people's absences, understanding whether anyone is getting into a habitual pattern or using leave or being absent way in excess of their entitlements is important. So let's drill down into the reasons for that a little bit more. So there are some very common causes of absenteeism. They often fall into these categories that we've got up on the screen now: illnesses or injury, mental health issues, bullying, harassment, high workloads, stress and fatigue, issues within their personal life, or could be a drug and alcohol usage problem, or just an disengaged worker. I have said well, it's important to address it if it occurs, so let's look at how you might do that. The first step is to gather some further information. If you suspect that there is a problem with the employee's absence, always look into having a conversation with the employee in the first instance around what is happening with that, and or there might be a need at some stage to formally write to them or seek further medical information. Gather what you've got first, so have a look at how many days has the employee had within a recent time frame or over the last year, what impact is that absence having on the workplace, have expectations on managing leave been explained to that employee and others, and then has that been applied consistently? Has the employee complied with any required policies? So have they been giving proof of absence and reporting their absences on time in compliance with any guidelines that you might have? So that's a little internal information gathering exercise. The next step is to invite an employee to discuss their absences, and you would ask what is the reason for the absence, inquire as to whether there are any medical issues that are ongoing, look at whether you need any further medical information, and can the employer offer some support in respect of that. And the next stage really is to set expectations in writing. It requires people to provide medical certificates for future absences, for example, etc. Now, we often get a question as to, can you ask an employee for further medical information? If an employee states that they have a medical condition, it may be appropriate that you request the medical information about the condition they have to ensure that you are supporting them as best as possible in their workplace, and to ensure from a health and safety perspective that their role isn't impacting on their medical condition, thus creating a risk to the workplace. Getting this information requires the employee's permission to allow you to access this information from the GP. An employee does, remember though, have good faith obligations, and they must be responsive and communicative, as does the employer. And so this is particularly relevant in these situations, because if an employee refuses to provide information, then they need to be aware that the employer can only act on the information that you have available, and it might be that you end up making some decisions that are adverse to an employee that might not otherwise be if you had the full information available. But given the employee's obligation of good faith, then to provide information, provided you have given them opportunity to provide information and consulted with them, sometimes that is the only option left to an employer. In respect of privacy, also remember that the information relating to the employee's health is governed by the Privacy Act. You need to ensure that any information that you do gather about an employee's health condition is only used for the purpose it was obtained, and that it can only be shared with certain people. So once you've collected that information, be careful how you hold that information and the purpose for which you use it for. Failure to keep that information confidential could, for example, be a breach of the Privacy Act. So that is managing absenteeism. If you've got employees with a pattern of absenteeism and you've got concerns, as I've said, collect that information, invite them to a meeting, discuss it. You can write to the employee with a list of questions that you might ask them to present to their GP if you're going to do that. Good tip is always to have the employee sign a consent to release medical information to you form at the same time, and ensure that you're writing to employees to ensure that you are covering off and making expectations very clear. Now I see that a hand has gone up from Ingrid. Do you have a question that you wanted specifically to raise now? Otherwise, feel free to pop that into the Q&A. No? Okay, we'll move on along. So we have got a case to cover at this juncture. This is DQJ and Commissioner of the Inland Revenue. In this particular case, the employee, who was known as DQJ, worked in a workplace support role at Inland Revenue. Over an 11-month period, DQJ developed a problematic attendance pattern. So she arrived late 77% of the time and was more than 10 minutes late on nearly half of all of her working days. In addition to chronic lateness, she was observed sleeping at work. She had tense interactions with most of her team. And she really just showed a general pattern of unreliability. The employer responded by holding meetings, issuing written expectations with respect to her, and regularly raising performance concerns with her. Despite these efforts, there was no meaningful improvement. So HR considered her to be frequently unavailable for work, not meeting basic expectations of reliability and general standards of workplace behaviour. Eventually, Inland Revenue decided to terminate her employment, not for misconduct or poor performance per se, but on the basis that the employment relationship had been frustrated. The employer claimed that the combination of chronic lateness, unexplained absences, and in-work sleeping made the relationship unsustainable. Importantly, this dismissal occurred without engaging a proper disciplinary or medical incapacity process. The employee's advocate argued throughout that her issues may have stemmed from unresolved trauma and possible medical conditions such as sleep apnea, and a request was made to delay a dismissal while this was medically explored, but Inland Revenue declined this and proceeded with the termination 2 days later. The employee raised a personal grievance with respect to unjustified dismissal for this, and the parties proceeded to the Employment Relations Authority, who then found that the employer had inappropriately relied on the legal doctrine of frustration. The authority held that frustration requires something exceptional and outside of both parties, not just a mix of performance and behavioural concerns. It emphasised that a fairer, more legally sound approach would have been to follow either a disciplinary or medical incapacity process, and while the authority declined interim reinstatement, the Employment Court later ordered interim payroll reinstatement, recognising that DQJ had a seriously arguable case and significant financial need, especially in light of the later submitted medical evidence that supported her arguments. So this case is a really clear example of how absenteeism and related concerns must be managed through established and fair procedures. Courts and the authority are unlikely to accept frustration as a valid reason to bypass these processes, particularly where a health or personal issues may be involved, and those have not yet been explored by the parties and worked through. So that's a case in respect of employer trying to rely on frustration. Next case is around misusing sick leave. This is the Wakaama case. It's one that you might have heard about in the media. It got a fair bit of attention at the time. So in this particular case, the court discussed the freedom of an employee to recuperate where they choose. And the issue here was less about attending an event and more about the honesties and the reasons for the sick leave and engagement in an investigation process. So the facts of this case were that T was employed as a program supervisor at a specialist youth services in Gisborne. She was in annual leave debt of 10.5 days. So the employer had already advanced her 10.5 days over and above her usual entitlements. She applied for 5 days off to attend a New Zealand Secondary Schools Waka Championships, which were held in Rotorua. The employer reluctantly gave 3 days, and as they had not heard from T, assumed that he'd be at work as normal. T came into work on the first day of the leave that he applied for, but claimed that he had injured his calf muscle and then went home again. He later travelled out of town that day and was seen by a colleague at the competition. He could not be contacted, and the employer then became aware of a photo posted on Facebook which showed T at the competition. In addition, the employer also had a letter from an event representative which stated that T would be at the rowing event. T was dismissed after his employer determined that he had misused his sick leave to attend the competition and that it wasn't genuinely in respect of a pulled calf muscle. So that's the background facts. What did the authority hold? Well, the employer sufficiently investigated the allegations, gave T an opportunity to respond. They genuinely considered T's explanations before deciding to dismiss him. So it was clear that there was no predetermination on the part of the employer, which T had tried to argue at the authority. The employer raised their concerns with T, and really there was one minor defect throughout the process, which was a failure of the employer to disclose that they knew about the photo posted on Facebook. The court held that this was a minor omission and did not result in T being treated unfairly, though it was of course good practice to ensure at all times that you're putting all information that you're basing your decision on in front of an employee through such a process. The employer followed a fair process, and the court found that T had misled, deceived and refused or failed to cooperate with the employer to the point where the necessary trust and confidence, which is expected in an employment relationship between employee and employer, had been lost, and so subsequently T's dismissal was justified. So this is note that an employee is not automatically abusing the sick leave if they're seen out and about doing their recreational activities. So this wasn't so much of an issue as to whether it was justified for T to be at the Waka event if he was on sick leave. This was more of an issue about having given the employer a reason that for being absent when in fact his reason was elsewhere. So quick case on that, for example, is the case of Wallace and Air New Zealand. Mr. Wallace was terminated after he was seen to be golfing whilst on sick leave. This was found to be unfair for many reasons, but also the Air New Zealand had made an assumption that because he was golfing, he wasn't sick. So he was actually going golfing to relieve his stress, which was one of the reasons for him being on sick leave. So it is difficult for an employer to determine and tell an employee where they should and shouldn't be when they're on sick leave, but it is important that employees are open and honest about their sick leave and the need for that sick leave. So two interesting cases, which brings us then to a discussion about, well, what happens when the absence comes to an end and the employee is ready to come back, especially where there has been a longer period of absence, and talking about how to reintegrate that employee back to work. So an employee does not need to be fully recovered to return to work. In fact, provided reasonable precautions are taken, then returning to work can be an important part of the recovery process. And we're seeing this more and more with respect to instances where employees, for example, have been off work due to a mental health illness, and sometimes being back within the workplace and getting reintegrated and having some meaningful work to do is really important for them. If there is an ACC return to work plan, the employer should be consulted with prior implementation of that plan, and once agreed to by both the employer and the employee, then it must be followed. The employee will have obligations to ensure that they are complying with the conditions of the return to work plan, such as getting the treatment that's required or not doing, for example, heavy lifting or taking the medication that's required of them, and the employer will need to ensure that they're doing their bit to comply from their end. For example, not providing heavy work if that's one of the conditions. Where an employee is nearly ready to return to work, an employer should be communicating with them about any appropriate health professionals in good faith about any reasonable accommodations that they might need. So you'll need to, of course, take into account the range of duties that the employee can do and cannot do during a recovery and beyond. In some situations, genuinely, there are no duties that an employee can do, and depending on the type of your organisation and the work you do, some employees may be able to do late duties and others won't. So, you know, for example, office workers might be able to do light duties, but if you've got somebody in the workshop and there are no alternatives for them, they might genuinely have no light duties available to them. You'll need to consider factors that are specific to the employee, for example, their general state of health, their age, access to support and treatment, their ability to adjust situations, etc. And you'll need to look at whether there's going to be a phased or partial return to work, and also then consider any reasonable accommodations that the employee needs for the return to work to be successful, and other sort of factors specific to the workplace, such as levels of flexibility to accommodate changes, sick leave, return to work policies, etc. To assess if an employee is fit to return to work, an occupational health officer, doctor, or appropriate person will need a detailed job description, including setting out the job tasks that the employee does, whether there are any physical demands or not in respect of the job, the hours of work, qualifications required, and the type of the work environment. Involving employees about decisions about duties is really critical about the success of a return to work, because it will have an individual case and there won't be a one size fits all, right? And important then to record any return to work plan in writing so that all parties are absolutely clear about how things are going to work. What happens though if an employee has been away from work for a significant period of time and there just isn't any indication that they are going to be ready to come back imminently or anytime soon? So where an employee is away from work or likely to be away from work due to illness or injury for a long time, and the general rule of thumb is about 3 months in these situations, the employer might consider terminating the employee's employment by way of what we call medical incapacity. Given absences for illness or injuries are not due to the fault of the employee, employers do in these situations have an obligation to balance the impact on their business due to the absence, and then fairness to accommodate employees' return to work where possible. Some illnesses or injuries just do need time to work through, and the employer will need to balance that with the impact of having that employee and supporting them while they're away. There are, as you'll see in a moment, some cases that set out what the rules are in these situations, and we'll go through them. But in general rule of thumb, an employer can dismiss an employee for medical incapacity, but in doing so, it must act in good faith and meet the test of justification. So as with everything, follow a fair consultative process before you terminate the employment. Ensure that you've got enough information in front of you to genuinely say that the employee hasn't got an immediate prognosis of coming back into the workplace. So a couple of cases on this as examples. We have the Littleton Port case, where an employee had been off work for a period of 12 months at this time. Wouldn't suggest that you need to wait 12 months before you kick off one of these processes. As I said earlier, general rule of thumb is 3 months, but genuinely some employers give their employees a long period of time and are supportive in trying to get employees back into the workplace. Some way down the process, the specialist confirmed that he was unfit to return to work with an uncertain prognosis, and so the employer then began a process to terminate for medical incapacity after Mr. Arthurs had been away for PTSD from a result of a workplace fatality. As the case proceeded before the court, there were some key principles on medical incapacity that the judge set out, and they are: the employer must give reasonable time to recover. As I've said, the rule of thumb is around 3 months. The employer must conduct a fair inquiry, balancing fairness and business needs. The employer must notify employees of the possible dismissal and seek their input before making any final decisions. And have a look at the employment agreements, the nature of the employee's role, the length of their employment. The longer they've already been with you, the higher the obligation to give them a bit of time to recover and get back into the workplace. So key takeaways from that case. Then we have the case of Crow in Kaiapoi Collision Centre. In this instance, the employee worked for a panel beater. He sustained injuries, provided a medical certificate when he would be fit to return to work. The employer was concerned about return to work and Googled the injury, discovering that recovery could be really long and difficult. And so the employer decided to dismiss the employee on the back of that. And the authorities held that the dismissal following a long-term absence will be justified if it can be shown to be substantially and procedurally fair. But the employer found that the employer had not adequately communicated the possibility of dismissal to the employee in this instance. They had not gone back to the employee to discuss their concerns about the employee's ability to return to work, which deprived the employee of an ability to respond. And so the authority determined that the dismissal was unjustified. And I think this is the last case that we've got on medical incapacity before we move on to the, nope, we've got another one. So another quick example is Hendy and Auckland District Health Board. Mr. Hendy was a registered nurse with ongoing issues affecting his work. He had experienced frequent absences and performance difficulties. The employer had provided support and made workplace adjustments, but certificates lacked any clear prognosis or return to work dates. The employer therefore sought detailed medical assessments and specialist input. Following that process, it was found that the employee was unlikely to recover, being able to do nursing duties, and the employer did explore alternative roles but found none were suitable. And after a consultation process, the employer terminated the employee for medical incapacity. That dismissal was then challenged, and the employee claimed that the process was not fair. The employer considered all of the steps that the employer had gone through, which we've just covered, and found that the employer acted fairly and reasonably throughout the process. So this is a case where there had been medical investigation, genuine attempts made to accommodate and look for other roles, and clear communication and consultation throughout, and so the employer was justified in terminating the employee. And I will leave the next case as we've got time to go on with looking at discrimination and culture and religion considerations. Now, I see that we've got quite a few questions, so I want to be able to leave some time at the end for questions as well. Right, so moving on along, the next topic that we are covering today is unlawful discrimination. So what happens where an employee asks for religious or cultural practices to be accommodated within the workplace and to have time off with respect to those? Well, in a nutshell, the requirement is to reasonably accommodate them. So where you've got religious and cultural differences accommodated in the workplace, the studies really show that the workforce is often more satisfied, stable, productive. You're able to more effectively retain skilled workers. But those accommodations can be hard, right? It can be at the expense of interruption with the employer's business or other employees taking on that workload. So the question that often arises in those situations is, what is a reasonable accommodation? So creating an environment that's intended to ensure equality of opportunity to meet employees' religious and cultural practices or needs of a person with some disabilities often requires that consideration of what is a reasonable accommodation. That really, again, is not a cookie cutter answer to that question. You'll need to look at the extent of the disruption to the employer's activities. Is the employee just asking to have their lunchtime at a particular time of the day, for example, or are they asking for extended periods of time away from work? Are they a key person within the business? All those kinds of considerations will need to be taken into account. As this next case provides an example of. So this was a human rights review tribunal case, which says that employers cannot discriminate against employees on the grounds of religion or any of the other grounds set out within the Human Rights Act. This was a case that involved a casual employee that worked a number of shifts. Then they turned around to the employer and told them that they could not work overtime on Saturdays by reason of their religious beliefs. On receipt of this information, AFCO indicated that this person's employment would come to an end, and he left the next day. Now, the employer argued that overtime was mandatory, that his employment was not terminated, he was just not offered further shifts because he was a casual employee, but the tribunal disagreed. Having looked at the background facts, the tribunal held that this was a case where the employer unlawfully terminated employment based on the employee's religious beliefs. So it was only on receipt of the information that the employee could not work on Saturdays because of religious considerations that he wasn't offered any further work. And this was a material ingredient to the making of the decision. The tribunal held the employer had a duty to accommodate religious practices of employees so long as the adjustment was not unreasonably disruptive. In this instance, given that there was no good faith consultation, they just received that information, didn't give any further shifts. The employer couldn't show that it was unreasonably disruptive. The employee in this instance was awarded $12,000 in lost wages and $15,000 for humiliation, loss of dignity and injury to feelings. And just a quick note about those numbers, this case was back in 2014. So if it was to be taken these days, the compensation and lost wages figures would likely be significantly higher as really the compensation awards both in the Employment Relations Authority and the Human Rights Review Tribunal have increased within that period of time quite significantly. So last slide before we go into questions, just some comments about ACC cover. Just a reminder that if the injury occurs at work, then the employer pays 80% of the employee's wages for the first week. It's then for ACC to cover that 80% until the employee is able to return to work. An employee, if it is an ACC case, will be assigned a recovery team that helps them with rehabilitation and provide the employer with the necessary information. If that is not happening, employees should be speaking to ACC to ensure that they are getting that support. And just one final comment about ACC is that employees, while they're off on ACC, they're still an employee. They accrue sick leave and they accrue annual leave within that period. And if you were to do anything with respect to their employment, ensure that you're following the correct processes, consulting with employees, and have the justification and a fair process that underlies that. So that is our presentation today. Ended up nearly, I wanted to keep 10 minutes for questions, but I'm happy to stay on a little bit longer because I see that we've got a great list of them. So Alice, do you want to fire away with some of the questions that have come through?
No worries. So the first one is, if an employee doesn't have any sick leave, can they use annual leave, and can an employer make them use annual leave?
You can't make the employee take annual leave if the employee is off sick, but you can allow the employee to access their annual leave if that's what the parties agree. Otherwise, the employee would be using unpaid leave, as I'd mentioned earlier. That was a nice, easy one to start with, Alice. What else have we got?
The next one is, when talking to employees about taking some annual leave due to high leave balances, can you include both entitled and accrued annual leave balances?
Yeah, sure, is the simple answer to that.
Cool. And the next one is, can the employer follow the same process for an employee to take annual leave, the same approach for alternate days? Is it appropriate for an employer to direct an employee to take their alternate days soon after they have earned the day?
Again, that's one that is probably best addressed in your policies and procedures. Ensure that you've got clear guidelines with respect to when employees are required to take those, and then hold employees to account with respect to those.
Right. And can we ask for a reason of why someone is off sick? We can do medical certificates after 3 days, but what about on day one?
Yeah, I would always ask an employee as to why they are off sick, and that just feeds back and helps you manage anything with respect to information that you might genuinely need to know. So, for example, they might just have a cold or a cough and be looking after a family member, that's fine. But if, for example, they're off because something's happened in the workplace, to preempt that, then you'll want to know about that, right?
Right. And how should an employer respond when an employee provides a medical certificate confirming mental health condition that makes it hard for the employee to attend work on a regular basis? And in the same time, the employee has already exhausted all their sick leave and annual leave entitlements.
Yeah, I would deal with that from a health and safety perspective, and be asking the employee to either come in and meet and discuss with respect to the underlying reasons for their mental health conditions, and or write to the employee seeking further specific information. You'll definitely want to know as an employer whether it is employment related matters that have led to that situation, or if it is just matters outside of the workplace that the employee is grappling with, private matters. If it is work-related matters, then you've got an obligation to investigate that, look into it, and understand what support you can provide to an employee to get them back. Otherwise, if it's a private matter, it's just ensuring that you are not doing anything within the workplace that is harming them further. So you do need to know about the underlying reasons and engage with an employee about that.
Fantastic. And if the person on sick leave for stress was seen out golfing, would it have been different if they said they'd had the flu or COVID? So in other words, like if they had a bad back, for example, in which they couldn't play golf.
Yeah, absolutely. So if an employee says to you, I've got the flu, and I'm in bed and I can't do anything, and that's why I can't come to work, and then they're seen out golfing, you definitely want to be investigating a little bit more around that. Don't jump to conclusions. It might be that by the afternoon they've felt better, and that's what the employee considers that they've needed in order to get them well enough to come back to work. But I would certainly be raising that with the employee and inquiring further into that, and then seeing where that lands.
Great, thank you. And then the next one is, can the employer dismiss for medical incapacity after 3 months if the person still has a sick leave balance?
No. If they've got an entitlement to sick leave, you'll need to let them exhaust that sick leave.
And what if the work is not able to be flexible, i.e. in construction, there is not often that there is not work that does not involve heavy lifting?
Yeah, absolutely. I don't know the context of that question, whether they're inquiring about starting off a medical incapacity process and how long you can accommodate that, or whether it is with respect to return to work duties. But absolutely, the nature of the work is one of many factors that feeds into an inquiry in respect of either of those processes, medical incapacity or looking at a return to work plan. If you can't reasonably accommodate it, then you can't reasonably accommodate it, but you should put that to the employee and give them an opportunity to respond to it.
Fantastic. Sorry, there's just a few other questions popping through. What if a staff member shows a pattern of taking sick leave every month?
Good question. Again, treat that as with any other frequent absence and talk to the employee about what is underlying that. And it will really depend on whether or not the employee has exhausted their sick leave entitlements or whether they're still working within their sick leave entitlements. But otherwise, have a talk to an employee to understand what the underlying causes for that are and whether, again, is it work related, likely personal is what I'm reading into that. But if the employee is within their sick leave balance still within that pattern, little that you can do about it. Otherwise, again, address it in a process or consultation with the employee.
Great, thank you. And can a business be considered discriminatory if it does not accommodate an employee's request supported by a medical certificate for mental health reasons, especially when the business has no viable options to allow the employee to remain employed?
Yeah, so the requirement to accommodate disabilities and mental health can be a disability. The requirement to accommodate that is on the basis that if you can reasonably accommodate it, or if you can't, then it's a justified reason for the discrimination. And so too, if putting the employee in that situation would create a health and safety risk for them or other people around them, that might be another justified reason for the discrimination.
Great. And if an employee asks for annual leave the night before required, can we ask to see proof of the trip he had last minute needed to take that had some issues with the week prior where he had taken sick leave and it looked like he was trying to avoid the job he was required to attend?
Yeah, absolutely. So the again, this loops back to the recommendation to have clear guidelines within your policies or procedures or your employment agreements as to how much notice is going to be needed for annual leave, etc. And then you can, if an employee is in breach of that, that gives you the grounds to decline that. But again, if it's unreasonable, you can't accommodate it, or you just want to dig deeper into that with the employee and look into the genuineness of the need, ask for proof.
Right. And do you accrue sick and annual leave on long-term ACC?
Yes, we covered that at the end, I think.
Oh, great. And what if an employee on ACC is seen out hiking? Who investigates this, ACC or the employer?
Good question. I would, as an employer, never leave it up to just another agency to investigate it. If you've got concerns around that, particularly if it's a workplace incident, then carry out your own investigation, because even if ACC did investigate it, you won't be able to rely just on what ACC have pulled together. An employer always needs to do their own investigation.
Great. And any comments on ongoing menopause symptoms impacting a staff member's ability to perform in their role?
Yeah, again, that comes under the disability area, really. What is the impact? Can it reasonably be accommodated? What are the symptoms for the particular employee? What support can you provide in order for those symptoms to be improved? There's great new technology in respect of where hormone replacement therapy is these days, but there is a serious disconnect between employees or people having access to that or understanding around it. So sometimes it might just be providing support and ensuring that the employee is getting the right medical assistance other situations might not be so easy to accommodate if it's ongoing or not responsive to treatments.
Great. And another one is if an employee takes significant amounts of unpaid sick leave and eventually states it's depression, what are the options to gain more information to ascertain whether they are getting medical help to recover?
Yeah, and I think we've covered that off in all situations, whether it's depression, mental health, an illness, or an injury. Always recommended to engage and seek further information. Write to the GP, ask if the employee is seeing a psychologist or a psychiatrist or a treating specialist, and seek to engage with that specialist with the employee's consent to get further information. So I see we're at 11:35. Alice, should we do one more question and then wrap it up?
Yep, I've got one that will follow on with what you've just said, and I'm assuming it's this particular person's got an employee who's declining to meet, has a medical certificate, has been off work on a non-work injury since April, but he won't engage with the occupational therapist. Any ideas?
Yeah, absolutely. So we touched on this earlier where I've said employees do have an obligation of good faith to engage, and if they're not, then you just might need to be making some tough calls on the information that's available. Write to them, outline your concerns about their lack of engagement with you and or with their treating specialist, outline that that is having an impact on really you might be able to give a message of that's giving us the message that you don't have an ability to come back to work currently. We're concerned about that. You might propose what the next steps are, for example, dismissal because of the lack of engagement and information that you've got available, and then still give the employee the opportunity to come back and respond to that before making any final decisions. But you will need to make it clear to the employee that you'll be making your decisions based on the information available if they're not engaging, and
Fantastic.
will
Oh,
make a decision without their engagement at the end, so long as you've totally warned them that's what's going to happen.
great. This is the very last question. So if an
Okay.
employee has gone into
Sneak it in.
negative sick leave, I'm going to sneak it in, i.e. you will deduct from future leave and they resign, can any sick leave be deducted from annual leave due?
Yeah, that's a tricky one. I would always recommend that you get advice from an employment law specialist before making deductions from wages, particularly these days, because if you make an unlawful deduction, then that can actually be seen to be a criminal offence. It's a new change that came in, was it just this year? And so get advice because it depends on what your employment agreements say, what your policies say in this situation.
That's all. Thank you very much.
Great. Thank you, Alice, for reading out the questions and being our technical help in the background here today. Thank you, everybody, for attending. We really value people signing up to these types of workshops and coming and getting informed. So we've got hand up from Grant. We'll take that and then we'll close off for the day. Oh, no. Did you have anything to say, Grant, or was that a mistake? No, great. All right. Thank you, everybody.